Welcome. My name is Dee Patters. I'm an immigration attorney at Catholic Charities of the Archdiocese of Dubuque, Immigration Legal Services. Our primary office is here in Cedar Rapids, which is where I am located. To give you a little background on me, I have been doing immigration law since 2008. Previous to that, I was an assistant county attorney in both Floyd County and Hardin counties, where I focused on victim-based crimes. So I do have a background in DV and sexual assault cases. Right now, what I'll do is I will go over to Zervang, who is the director here at Immigration Legal Services, for her to introduce herself. Then she'll bring it back to me and we'll start the presentation.
Hi, good afternoon, everyone. Thank you for joining us this afternoon for, I hope to be a thrilling and informative session on Immigration 101 for advocates. My name is Zervang. As Dee mentioned, I serve as the legal director for our Immigration Legal Services program with Catholic Charities of the Archdiocese of Dubuque. And like Dee, I'm also located here in Cedar Rapids. We're just kitty corner from Waypoint in Cedar Rapids. And so we really value our collaboration and partnership with Waypoint and Riverview Center. And so I really just want to thank both agencies for reaching out to us and asking us to present information that I think is timely and really important, especially given the line of work that you all do. And we hope this to be, even though we're going to be sharing information, a really good opportunity to have conversations and answer some questions that you may have.
Thanks, sir. First of all, we'll just do a little background on Catholic Charities. We are a social service agency. We respond to persons in need regardless of faith. So even though we are affiliated with the Catholic Church and the Archdiocese of Dubuque, we have clients who are Muslim, who are Jewish, who are non-affiliated or atheist. It doesn't matter. We're here to serve anyone who needs it. Our real dedication is working to achieve justice in our society. And of course, for us, it's through providing low-cost immigration legal services. So we serve 30 counties in Northeast Iowa that comprise the Archdiocese of Dubuque. If someone lives outside those 30 counties, then they're outside our service area, but we can certainly refer them to another legal services organization who covers that territory. So what is Immigration Legal Services? It's our program here at Catholic Charities to provide affordable, quality legal services for immigrant families who need help, whether it be to get their green card, to apply for asylum, to apply for citizenship, which is one of my favorites. I love helping create new U.S. citizens. Petitioning for family members who are abroad. We deal with some unaccompanied minors and some VAWA and U visas, which we'll get into later. Okay. So what is this presentation going to look like? One, we're going to do an overview of the federal immigration system. Two, we're going to look at immigration benefits that may be of interest to you and your clients. So those are the non-immigrant crime victim U visa, violence against women self-petition, trafficking victim T visa, special immigrant juvenile status, and VAWA cancellation of removal. Hopefully provide some more useful information to you, and then we'll have questions and discussions. What federal government agencies are associated with immigration? It's primarily the Department of Homeland Security, or DHS. This was, of course, established in 2003, and it eliminated the former INS. The agencies that are relevant to us in DHS are, first of all, USCIS, which is the U.S. Citizenship and Immigration Services. Two, ICE, which is the Immigration and Customs Enforcement, and three, CBP, which is the Customs and Border Protection. Department of Homeland Security. So the USCIS is responsible for immigration services and functions for the federal government. So it handles applications and petitions. The CBP, they're responsible for protection of our border. They deal with admission. So at ports of entry, apprehends undocumented immigrants at the border. And then ICE is the investigative branch of DHS. And so they're the ones who are in charge of apprehending immigrants within the US, not at the borders. And they also are the ones who supervise any undocumented immigrants who are in immigration court. The Department of Justice, so mainly dealing with immigration court. So this is immigration court's official name is the Executive Office for Immigration Review, or EOIR. So it's part of the executive branch of the US federal government. It is not part of the judicial branch. So it's an administrative law court. It's not a court like a district court. So functions of EOIR, there's the immigration judges. So all of the cases here that originate here in Iowa are heard in the Omaha, Nebraska Immigration Court. We'll talk about them maybe a little later. They're not the best court in the nation when it comes to approvals for things, unfortunately. There's also the Board of Immigration Appeals, which is the first appellate level if there is decision from immigration court that someone would like to challenge. Okay, moving on. Who is an immigrant? So it's any resident of the United States that's not a US citizen. So what does that comprise? So we've got our undocumented persons, people who have green cards, who are also known as lawful permanent residents. We have refugees, asylees, parolees, people with temporary protective status, people with DACA. And again, just a tip, please don't use the term illegal alien. Instead, use undocumented person, because being solely present in the United States without documentation is not a criminal violation. It's a civil violation. Framing someone as illegal is a way to dehumanize them in some respects. And we would like to give the people we serve a little more agency and respect than that. Definitions: US citizen. So US citizenship is either by birth or naturalization. Anyone born here in the United States, on the territory of the United States, is a US, I shouldn't say that, because there are territories and that gets complicated. So basically anyone who is born within the US states and Puerto Rico is a US citizen by birth. And then you can also apply for naturalization to become a US citizen if you meet certain qualifications. Lawful permanent resident, also known as green card holders. So they have permission to work and live in the US indefinitely without restrictions. They can travel outside the United States and re-enter. Lawful permanent resident can be revoked, but it's a pretty complicated process, but there is that mechanism where if there are issues that meet certain criteria, immigration court can put them into proceedings to revoke their status. Refugee. So that is an immigrant who is living abroad, who was seeking protection in the United States due to persecution based on religion, nationality, membership in a particular social group, or political opinion and race. They're from a country of origin that they can't return to because their government is going to harm them or may harm them. And that is versus an asylee or an asylum seeker, who is someone who seeks the same once they're in the United States. So refugees come into the United States as refugees. They usually go through the UNHCR, which is the UN agency that handles refugees. But asylees are people who are in the United States who say, hey, I meet the requirements for being a refugee, but I'm in the United States. So they start the process here. Asylum seekers can either file affirmative applications, which means that they entered the United States usually legally, and that application goes to USCIS. Individuals who are in removal proceedings in immigration court can also do a defense of asylum, where they make that application to the immigration judge. Okay, a visa. So this is a document that's issued by the Department of State to foreigners seeking lawful entry to the US. And then there's deferred action for childhood arrivals, which is a program that allows certain individuals who have been here to be protected from removal and have employment authorization. There are certain pathways to lawful status in the US. One that we deal with very often here is the family-based immigration. So that's if you have a US citizen or a lawful permanent resident in the United States, or even a refugee or an asylee who has family abroad usually, and depending on which category they fall into, there are certain relatives that they can petition for. They do a petition with USCIS to establish that family relationship to show that they're a qualifying relative. And then the next step is they go through the Department of State to do consular processing, where the person then applies for an immigrant visa and then submits that to the Department of State. They then later have an interview at a US embassy or consulate, and then the decision is made and they come to the United States, hopefully. Humanitarian relief. So looking at asylum and then refugee, we have our special immigrant juvenile status, which is a status that some unaccompanied minors or persons under 21 years of age who have been abandoned, abused, or neglected by at least one parent, they may fall into that category, which we'll talk about in a few moments. Temporary protective status. which is a designation by the federal government that looks at a country and says, right now, it is not safe for citizens or residents of that country to return to that country because it could be a natural disaster, it could be political strife. But the US government looks at this and the executive branch makes a decision and says, for this country, we're going to designate it for TPS. Those designations are done in 18-month increments, which can be renewed. And sometimes they're renewed for many, many times. The thing about temporary protective status is that it is temporary. So this is not going to lead to the ability in it of itself to get a green card or US citizenship. As I mentioned, the Deferred Action for Childhood Arrivals. There's also the Violence Against Women Act, which we'll talk about. There are 2 routes that you may be able to get humanitarian relief from removal for that. And then there's the U crime victim status and T trafficking victim visas, which we'll also get into. And sort of the other branch of immigration would be employment-based immigration, which is something that we here at Catholic Charities that's outside our scope of representation. So what immigrant benefits for your clients should you know about? 1, the U visa. 2, the VAWA self-petition, the T visa for trafficking, special immigrant juvenile status, and I forgot to add in here VAWA cancellation of removal, which we'll talk about. As advocates, what are the tips that we can give you? So first of all, of course, please help support your clients when it comes to their immigration statuses and the immigration challenges that they may have. You can advocate for them through investigations and prosecutions. When someone is working with an attorney, you can help gather evidence such as police reports, medical evaluations, shelter records. You can assist in establishing legal guardianships for unaccompanied minors. And I will say, in my experience, one of the other things that the advocates play such an important role is just being there to support their clients. So they can accompany their clients if their clients, give them permission to appointments with an attorney. They can really be there to help bridge the relationship between your client and the attorney, and together to help try to create a safe space for them to explore their immigration options. Because of course, you're going to know them, much better than we are when we first meet them, and they trust you. And so having you involved in the process, I think, can really make it smoother and easier for your clients. So let's talk about the first benefit. So this is the non-immigrant crime victim U visa, often referred to as just the U visa. So it was established to encourage victims to report crimes and cooperate with law enforcement without having to be afraid of deportation. So this is available even for non-citizens who have a prior criminal history. If they fall into certain categories, a waiver may be possible for them. So the non-citizen must have been a victim of a crime that occurred within the United States. So if you have someone who is a victim of a crime in their country of origin, unfortunately, that does not count. The crime must fall into a qualifying category, which we will get into in a moment. And this is sort of the most important thing with U visas that I don't think people necessarily automatically understand, is that it doesn't matter whether the perpetrator of the crime was convicted. They don't even need to be arrested. The important thing is that the victim was helpful to the investigation. And that is what's needed in the application for the law enforcement certification. This is available for certain individuals to be able to say, yes, this person helped with our investigation, even if it did not result in a charge or an arrest. So the perpetrator's immigration status is irrelevant. So that means it doesn't matter if the person who committed the crime is a US citizen, lawful permanent resident, or an undocumented immigrant themselves. With the U visa, you can have derivative beneficiaries. Derivative beneficiaries are people who can derive the same status from the principal applicant based upon their relationship to the principal applicant. So for the U visa, we're looking at spouses and unmarried children under 21. If the applicant themselves is under 21, parents and unmarried siblings under 18, and the ages of beneficiaries are frozen if the applicant turns 21 while the U visa application is pending, which means they could not have turned 21 before the U visa is submitted. Also, marriage breaks the eligibility of the unmarried children and siblings. So we'll get into qualifying crimes. So it's a long list, but it covers a lot, which is great because it really does have a wide range of crimes that may qualify for this, which makes it the opportunity for more people to qualify. So first of all, we have domestic abuse, which is again your family member or partner who assaulted or harassed the person. Felonious assault, such as shooting, stabbing, mugging, or home invasion. Involuntary servitude, being forced to work when the person does not want to. Peonage, which is being forced to work when they don't want to pay off a debt. Rape, sexual assault and abuse, forced prostitution, sexual exploitation, any female genital mutilation or cutting, incest, kidnapping, abduction, unlawful criminal restraint, false imprisonment, manslaughter and murder, torture, trafficking, blackmail, extortion, obstruction of justice, witness tampering, perjury, or an attempt or conspiracy to commit any of the above crimes. So as long as the criminal conduct of the perpetrator meets the definitions of those crimes, then the crime itself is qualifying. Again, does not have to be arrested for it, does not need to be convicted of it. So we talked about the law enforcement certification. This is a form that law enforcement must fill out to certify the petitioner's crime and helpfulness. So qualifying authorities include police, prosecutors, judges, child protection workers. When I was prosecuting, I actually did a few of these myself. They're best procured by an immigration attorney. And sometimes we'll see that the authority may be hesitant to want to certify the crime for a U visa because of political considerations or bias. But the emphasis should be that the certification is only providing facts. It's only saying that this happened, this person was helpful to the investigation, and that it is USCIS that is responsible for making the immigration benefit determination. I worked for a Republican county attorney when I dealt with one of these certifications, and that is essentially the argument that I made to him when he was hesitant to become involved in certifying the crime for a U visa. But again, all it's saying is that these things happened. So once a U visa is filed, the first hurdle to get over is USCIS will look at the application and want to create a bona fide determination. So the standard for this determination is they're initially going to review the U visa application to see that it demonstrates that it is a complete application, that it is properly filed, and then they'll make sure that the criminal background check does not raise any national security, public safety, or other concerns. So once the bona fide determination is made, the person will be given deferred action, which means that they'll be protected from deportation or removal in immigration court proceedings. And they're also eligible to apply for employment authorization, work permit, EAD. This will have a 4-year validity period, and it is renewable. If USCIS looks at an application and they decide that it does not meet the criteria for a bona fide determination, they will then look to see whether it can be waitlisted. So the standard is a little stricter with this. So they have to look at the application and say, based on everything, it appears on its face that it is approvable because the applicant meets all of the U visa eligibility criteria. Again, this is not the decision on the U visa itself. Instead, they just take a look at it and say, if everything on here is what it says, it looks like it's approvable, then they can go on the wait list. So the benefits are the same as the bona fide determination. So again, that's deferred action, protection from removal or deportation, and ability to apply for a employment authorization document. So U visas are great because there's a large number of people who should qualify for them because of the wide range of crimes that are qualifying. The downside of the U visa is processing times. So there is a quota for how many U visas can be given out per year. It's 10,000, but those are strictly for the victim petitioners. Those don't count any derivative applicants. The current backlog, I looked today, and the most current number I could find was about 190,000. So if you do the math on that, and if things would remain the same, I mean, we're looking at probably a good 20 years, if not frankly 30, if more people keep applying. But the bona fide determination is supposed to decrease the wait time for employment authorization and deferred action because of this huge wait. Again, giving people the ability to support themselves legally and protection from removal while this very long process is going on. Again, I checked today to see sort of what we're looking at time-wise. And unfortunately, it's still looking at about approximately a 5-year wait. During that time between the application and that determination, they're not eligible for an employment authorization document. So the wait list takes even longer. The number of people applying and the backlog is just it's horrible. But at the same time, if this is the only route for somebody to get legal status, then use it, right? And again, with U visas, the end game is they will eventually be eligible to apply for a green card and lawful permanent status. VAWA self-petition, again, that's Violence Against Women Act. So this was created as a pathway for individuals who would normally be sponsored by their US citizen or lawful permanent resident spouses to be able to apply for those same benefits even without the US citizen or LPR relative, in cases where there is domestic violence. Important qualifications for this: you have to be married. The person does need to be a US citizen or lawful permanent resident. So the law requires that, so the immigrant spouse has to have entered the marriage in good faith. When you apply, you have to provide documentation of that. The perpetrator spouse has to be a US citizen or lawful permanent resident. The immigrant spouse must be a victim of abuse or mental cruelty. When we say that, there is not a need for a conviction of domestic violence. You can provide other documentation of it. Of course, a conviction always helps. But again, just want to make sure you understand that it's not only available for people whose spouses have been convicted of DV. You also must file within 2 years if there is divorce, or within 2 years if the abuser loses their immigration status. Next up, we'll look at a trafficking victim T visa. So available to non-citizens who are survivors of a severe form of trafficking or attempted trafficking, which includes labor trafficking and sex trafficking. They must be physically present in the United States or at a port of entry, which means an official crossing point at the border, on account of the trafficking. And the immigrant must have remained in the US since the most recent act of trafficking. The applicant must comply with any reasonable request for assistance in investigating or prosecuting the trafficking if 18 years of age or older. And there must be a risk of suffering extreme hardship if they are removed from the United States. Moving on to special immigrant juvenile status. So this is a pathway for non-citizen immigrant children under 21 years old, according to the law, who are in the state juvenile system who cannot reunify with at least one of their parents due to abuse, abandonment, or neglect. There's other criteria they also need to meet, such as being unmarried. And again, this is a pathway that they can eventually be approved for SIJS, as we often refer to it. And once they have the visa available, the SIJS visa, then they can apply for their green card. It is a unique process because it requires a state court order, state juvenile court order, as a prerequisite for filing the special immigrant juvenile status application, which is called an I-360 with USCIS. So what that means is that the non-citizen child must obtain a legal guardian through the state court system. And the juvenile court must find in its order that the child cannot be reunified with one or both parents due to abuse, neglect, abandonment, or similar grounds. We have done many of the SIJS cases here in our organization. Sometimes we have outside attorneys who assist with seeking the legal guardianship in state court. Occasionally, our attorneys may assist with that. The thing to remember with this too is that even though the federal law says under 21 years old, in general, it's more successful if the child is under 18. especially dealing with juvenile court. It is not a hard disqualifier. It is a very much a real challenge if the child is over 18 and under 21. So again, the process, you need the state court guardianship order. I looked at how long it would take to be able to apply for a green card if you were approved for SIJS. I recently had a client who filed in March of 2019 become eligible to apply for his green card. So you're looking at about 5 years. Of course, that's going to vary. There is a quota for how many of those can be given out per year as well. Another issue is that there's no temporary status or work permit provided when the application is pending. The nice thing is there has been in the last few years a change in which once the SIJS application, the I-360, is approved, then those individuals are given deferred action, which again protects them from removal in immigration court, and also allows them to apply for a employment authorization document so that they may have work authorization here in the United States. Another feature of SIJS, though, is that in the future, they cannot petition for a parent if they become a U.S. citizen, if they started their legal pathway through the SIJS process. VAWA cancellation of removal. This is only available through remover proceedings in immigration court. So the VAWA self-petition, you don't have to be in removal proceedings to be able to do that, but for cancellation of removal, you do. So what are the requirements? They're a little more expansive than the VAWA self-petition, which is nice. So you have to be subject to battery or extreme cruelty, again, by U.S. citizen or lawful permanent resident spouse, child, or parent. You have to be in the U.S. for at least 3 years before the start of your removal proceedings. You have to prove good moral character for at least the past 5 years. What that is, they're going to look at any crimes. They may look at other things that, that they've been involved in. So removal would also cause extreme hardship to the applicant or their children or parents, and they have to be not subject to any grounds of inadmissibility. So the persons that are eligible for VAWA cancellation of removal, as opposed to VAWA self-petition, is that if you are a parent of an abused child of a U.S. citizen or lawful permanent resident who is not married to the other parent, you can be eligible for VAWA cancellation of removal where you're not eligible for VAWA self-petition. Also included are spouses of U.S. citizens and lawful permanent residents who have been divorced for more than 2 years. And lastly, adult over 21 children of U.S. citizens or lawful permanent residents. Okay, immigration trends in Iowa. Immigration is always in the news, so you guys may have heard of a lot of things that are going on both federally and locally. Immigration law and policy, it changes all the time. When I was a prosecutor, I look back now and sometimes wistfully and think of criminal law and how sort of stable it was. Like there may have been changes that come every once in a while, but you sort of knew when they were happening and they were, everybody was on board with them. Whereas with immigration law, it seems like it can change sometimes week to week. It's been a little more stable since the Biden administration. During the Trump administration, though, I literally had to spend so much time each week just checking to see if anything had changed to make sure that I was giving current and valid legal advice when I was doing my consultations, because things would change. So we do have a current bill that passed both the Iowa House and Senate that is making news and is a big deal. Surveying, our director, has been very active in advocating against it. And so she knows lots about it. And I'm going to turn it over to Zur to talk about this bill.
Sure. Thanks, Dee. So with this particular bill, actually, with the start of the new legislative session here in Iowa, there were 4 bills that were proposed, all coming from the majority Republican Party that we would deem as anti-immigrant or not immigrant friendly in the state. Just a quick summary of those. One was a bill that sought to deny in-state tuition for non-citizens here in Iowa. So even if you've lived here for X number of years, and as long as you are not a citizen, particularly addressing or targeting undocumented immigrants, you cannot benefit in-state tuition, right? And Fortunately, that bill did not proceed and advance. A second bill that was proposed was a bill called essentially e-verification, which would require employers, all employers in the state of Iowa, to participate in this federal e-verification system. It sounds on its face like, oh, it sounds like a pretty neutral program, but we know in practice, at least on the federal level, when programs or employers participate in e-verification, it leads to a lot of problems, particularly undocumented, and not just undocumented, but Black and Brown employees who are majorly targeted in finding that their maybe Social Security numbers or A numbers didn't match the system, and then they would then be impacted in terms of being terminated, having their employment terminated. So fortunately, that bill also did not proceed and advance any further than subcommittee meetings and vote. A third bill, we called this bill the anti-smuggling, anti-immigrant bill, in that it was alleging that it would make it a state crime if you were found to transport, and it could be vehicle, taxis, Ubers, Lyfts, someone who was undocumented in the state of Iowa. So this impacted, if you can imagine, a large number of individuals, including advocates like yourself, who may be assisting an undocumented survivor to go to court, to go to the medical appointments, to come to see us. You, as an advocate, potentially could be pulled over by law enforcement and then cited maybe with a traffic violation for whatever they pulled you over for, or if they didn't cite you for that, but then allowed to ask questions about the passengers or the driver of that vehicle, their immigration status. And if you did not have legal status, you could then be arrested for transporting an individual who was undocumented, right? And so that was the summary of that bill. And it also attached a portion about also making it even more challenging and difficult for undocumented immigrants to access public benefits, which you already know that undocumented immigrants don't qualify for federal means tested benefits. So this bill really was intended to really chill individuals, particularly immigrants who actually could access public benefits from not accessing it, but also really chilling and really interfering with people's ability to serve and provide humanitarian services like organizations like Waypoint and Review in terms of serving undocumented survivors of abuse. And so fortunately, that bill, with the large significant testimonies and public outcry, that bill did not advance any further than the respective Senate and House votes and committee debates. This last bill that's on the slide here, which is Senate File 2340, it has a companion bill, which means that the Senate the Senate side introduced the same bill as well as the House side of our legislature. And this bill is what we call the federal preemption bill. It's another anti-immigrant bill, in that what this bill actually says is anyone who is found to be undocumented in the state of Iowa, or anyone who is found to travel or come or enter the state of Iowa that's undocumented, would be arrested and detained, prosecuted under this new law in violation of being here undocumented, and then processed through our criminal court system in the state of Iowa. And then our state judges would then be authorized to, quote, order a deportation against the individual who is undocumented. And so basically, you can imagine multiple reasons why this bill is problematic. One, this is essentially a copycat bill. And we call that copycat because there are other states that are utilizing the same language as our Iowa bill. For example, Texas actually last year passed this very similar law, and it was actually going to take effect in March of this year, this month earlier. But ACLU and the County of El Paso sued the state, and through litigation right now as it stands, the federal Fifth Circuit Court, which oversees the jurisdiction in Texas that overhears federal legal litigation, has put what we call a pause or an injunction, a stay on that order. So what that means is the Texas law is not going to go into effect until they fully litigate and brief the issue and it can be heard with the Fifth Circuit. So this bill in Iowa mirrors and is very similar to the Texas law. Unfortunately, what happened literally just a week and a half ago was that this bill did advance and went through both houses, both House and the Senate, and passed. And so we're just waiting for Governor Reynolds to sign this bill into law. By all accounts, we believe Governor Reynolds will sign this because of her previous actions and rhetoric regarding undocumented immigrants and her support of what's happening down in Texas, sending our Iowa National Guard down there to help supposedly with the individuals entering the southern border. What is going to remain undetermined at this point is if Governor Reynolds does sign the bill, the effective date of this bill will be July 1st of this year. We are hoping that there would be similar litigation here in Iowa to help stop the bill, if not litigate it so that it actually is found to be unconstitutional. But we know that unfortunately, things don't always work the way we would rationally imagine them to be, even in the legal system. So there are a lot of conversations in the community. So especially for advocates, Waypoint and Riverview, I know that there are many of your colleagues who are, tracking these policies and these legislation. The governor has not signed it yet, but I think that it's important for advocates to also be involved in the community, to be aware of this law that most likely will be signed into law by Governor Reynolds, and then help our community understand the law and help to address how we can support each other during times when it's going to be difficult. And so stay tuned. If you aren't tuned in, please feel free to reach out to me. I can connect with Catholic Charities. We can connect you with the larger immigrant rights organizations in the state of Iowa to help really resist and advocate on behalf of immigrants who are going to be impacted. And it's just not just immigrants, it's going to be organizations like ours that will be greatly impacted with this type of legislation. I'll leave it at that, just in terms of a quick update for those laws. And then if folks have questions, we are more than happy to answer questions afterwards as well. Thank you.
Okay. We do anticipate that if this is signed by Governor Reynolds, there's going to be many immigrants who have questions about it. And unfortunately, right now, the way the law is written, we don't know how it's going to be enforced. There's no, specific roadmap necessarily for law enforcement. So unfortunately, there's just a lot that we don't know right now. I very much hope that there will be litigation, which if it's signed, it will be stayed and won't go into effect in July. But as Zur has reminded me, we don't know what's going to happen. So we need to be prepared for each eventuality. Other immigration trends in Iowa. Again, we talked about in the U visa section about these case backlogs at USCIS. Immigration court also has some pretty significant backlogs. Currently, I have a pending asylum case in the Omaha Immigration Court that was filed in, I believe, 2019, which is set for its asylum hearing in 2026. So that's what you're looking at. I recently had a case that was transferred from the Omaha court to the Chicago court. I just got a notice today that he has a master calendar hearing, which is sort of like a status hearing. It's not even like the actual asylum hearing. And it's not scheduled until 2025. So we're looking at really long periods. Speaking of the Omaha Immigration Court, it's not necessarily so great for immigrants here in Iowa. So the Omaha Immigration Court, when it comes to asylum, has the lowest approval rate for asylum for any court that has jurisdiction over undetained and detained persons. There's a couple of courts that deal exclusively with detained individuals who have a worse record than Omaha, but Omaha is pretty down there. It's to the point now that It's less than 4% that are granted for defensive asylums in immigration court. Whereas if you look at the Chicago court's approval rate, it was over 60% last year. So the difference between 4% and 60% is pretty stark. My legal advice to my clients is usually get your case out of Omaha, because we don't want the odds stacked against you. You know, if you have the ability to move to a jurisdiction like Chicago, which has a much higher approval rate, why not do that? Because the difference between 60% and 4%, I think it's something like you have a 21 times better chance in Chicago than you do in Omaha. And that's pretty mind-boggling to me. And we don't know exactly why. We are working on it with other immigration attorneys. There are a few reasons why that have to do with which Circuit Court of Appeals we're in and the case law that's associated with each appeal circuit. But at the same time, that difference it should not account for that. So let's talk about benefits that are not available to undocumented immigrants. So undocumented immigrants, they can't get CHIP, they can't get SSI, they are not eligible for SNAP, they're not eligible to purchase insurance policies under the Affordable Care Act, they're not eligible for Medicaid or Medicare, Social Security, or welfare or temporary assistance for needy families. There are some benefits that they may receive, which is emergency medical care, to go to the ER, schooling for their children, and they do qualify for WIC. So again, we talked a little about advocacy response in Iowa. So know your facts. That's one of the reasons why we're here today, is to provide you with those. Speak up on behalf of immigrants, refrain from using terms like illegal or chain migration, support national and local legislation that improves lives, improve legal access for unaccompanied children, Central Americans seeking asylum, DACA eligible students, create safety nets to support immigrants. And again, as advocates who work closely with traumatized populations, you can be a real strength in that safety net for them, and advocate for them, not only for the, in reference to the domestic violence, but also, helping them with the immigration piece as well. Organizations promoting immigration rights. So there's faith-based organizations, there's legislative and advocacy groups, Catholic Charities. There is a great organization in Des Moines called the Iowa Migrant Movement for Justice, or Iowa MMJ, that does terrific work. There's also national and local immigrant rights and advocacy groups. There's the Northeast Iowa Peace and Justice. These organizations will often do know your rights training to help educate others, including immigrants and people who work with immigrants, the general public, just to make sure that everyone is informed and know what rights they do have. We anticipate, if the bill is signed that we spoke of, that there will be an increased need for know your rights trainings. We are ready to help provide those. So there's resources on immigration. Some good ones are the Pew Research Center. There's the Migration Policy Institute. The Catholic Legal Immigration Network, or Clinic, is an amazing resource. Here at Catholic Charities, we are an affiliate of that network. Interestingly, when I first came to Catholic Charities, I did not realize before I started that Catholic organizations are the largest legal services providers in the entire country. So this is something that, the Clinic is a large organization, and they have wonderful resources. So American Immigration Council, Immigrant Legal Resource Center is wonderful as well. And this is our contact information. Please take it down. Feel free to call us. Feel free to email us. I do just want to take a second and talk about sort of what role you have as advocates. So we've given you a lot of information today, and the purpose of that is to educate you to what may be possible for your clients. If you identify a client who you think may be eligible for one of these benefits, what you should do is set up a consultation with an immigration attorney so that that attorney can gather all of the information, look at all the details, and determine what they are eligible for. Here at Catholic Charities, we provide free legal consultations at no charge. So if you have a client, you see that they may be eligible, go ahead, give us a call, start the intake process, which you can help them with, for them to come talk to us. And then we do offer representation for all of the benefits that we talked about today. I know I have a background with DV. Zur has a background with DV, and I personally get a lot out of helping because that work was really important to me while I did it. So we want to make sure that we're not asking or seeming to put the onus on you as advocates to decide whether or not they are going to qualify for a benefit, because that's really something that an immigration attorney needs to look at everything and the whole picture to determine. What we envision your role is as more just having this information, sort of thinking about your client, screening it, and if there's a possibility that they may be eligible, get them to meet with a immigration attorney, whether it's us here at Catholic Charities or a different immigration attorney, to explore their options.
We do have multilingual accessibility in our office. Make sure folks are aware of that. In our office with our ILS team, we offer 8 total languages. All of our legal assistants are bilingual in Spanish and English, but we also have team members in our office that speak French, Lingala, Swahili, Pashto, Dari. We have volunteers that also offer Haitian Creole as well. So we know that language barriers are oftentimes the very first things that prevent someone from accessing your services and our services. So we want to make sure you're aware of that as well.
If no one else has any questions or comments, it was a pleasure to be able to present to you today. I really hope that this is the catalyst for some more collaboration between our organizations. And again, we are here if you need anything. So with that, thank you so much and have a wonderful day.
Thank you, everyone.
Thank you.